Hi, it's Andrew Price at the Venable Law Firm, and I want to thank everybody for joining our webinar today, focused on maximizing the value of brands and creative works in challenging times. It's certainly been a challenging time for the last 17 weeks or so. So I'm thrilled to be with you for the next hour and speak with my colleague Megan Kent, who will cover the copyright aspects of today's webinar, and she and I work closely together on a regular basis. And we're really thrilled to have Jennifer Hammer, who comes to us as Vice President of Community and Branding at Association of Talent Development. And so she'll have some very interesting comments to make, I think, as we talk about, in particular, how to address the challenges of rebranding. So we're going to organize today's webinar with about the first two-thirds focused on trademarks, maybe the next third focused on copyright, and then we're going to have questions at the end. So we're going to roughly follow that organization. So starting with trademarks, I just wanted to introduce the Venable trademark practice for those of you who are not familiar with it. We have a real long-standing history that we're really proud of. We're part of what we like to call an IP powerhouse after bringing the Fitzpatrick Cella firm into Venable a couple years ago. We have always really high rankings from a lot of the ranking services, and I think importantly are a top 10 to 20 filer of trademark applications, which just means we're busy. And so you kind of view us like a boutique trademark practice that you might find in a boutique IP firm, but located in a big general practice firm with, of course, our great nonprofit team. And we've always had a focus and a strength in our group on diversity and inclusion. So we're more than all that as well. We're focused on charitable efforts, and there I am with some other Venable professionals performing with our band Noise in the Basement. We've raised a lot of money for charity over the years. So I wanted to give a quick overview of U.S. trademark law, and I would just note the rest of the world's not too different. We're going to kind of race through these initial slides because, you know, this is just kind of setting the table to make sure everybody knows some of the language we're using, but it's very basic, so bear with me as we go through these. So when I use the word trademark, or the word brand, I really mean the same thing. And frankly, from a business point of view, most people think of trademarks as brands, and that's really what they are. And trademarks can be a lot of things. Here you see, you know, we've got traditional, quote, trademark service marks, and then other varieties here that I'm going to go through. The standard kind of trademark or service mark is generally used, that word trademark is used to refer to both trademarks and service marks, and that's the typical thing you see in the upper left-hand corner of your websites. You'll see a logo that has often a design element, an acronym, and a full name, and so those are your classic kind of trademarks or service marks. There can also be collective membership marks, and there is the American Bar Association rebranded logo, and virtually every association client will have this. This is just something that indicates that a person is a member of an organization. So it's something you see, for example, on a membership card. Certification marks are really interesting in the nonprofit context because while they do exist in some cases, what nonprofit folks call certifications are really often different from what trademark law would call a, quote, certification mark. So in the case of a certification mark, it's really just saying that when you see this trademark, it's an indication that certain standards are met by that provider of goods or services. And there you see the PMI REP logo, Registered Education Provider. So what is not a certification mark is the credential that many nonprofits award and test for, and that is what you might loosely call a credentialing mark, or really a typical service mark for testing and awarding credentials, and we'll talk more about that. There are other types of trademarks. Your trade name, your association or nonprofit name is a trademark. A domain name can be a trademark, and there was a big case recently called Booking.com that opened up kind of the universe of trademarks that can be registered as such, and so that's good to keep in mind. And trade dress is also possible, and that's the look of a product or its packaging. And there you see the Emmy statuette there. That's a trademark in the nonprofit space. And so trade dress is certainly not that common for nonprofits, but those are the different types of trademarks just to set the landscape. There's some special features of U.S. trademark law, and it's always interesting, I think, for people to know that the focus is the consumer, it's not the trademark owner. And that unlike the rest of the world, the U.S. is not a first-to-file country. So what that means is you can have trademark rights in the U.S. based on your use of a trademark, not necessarily registration, although registration is viewed as very important. In foreign countries, you often have to be the first party to file. And why do we file trademark applications? It's to try to get a presumption of nationwide rights in a brand as of a filing date. So we also have to consider trademark infringement and kind of the worst case scenario if you're using a brand and it's called into question. So I always like to talk about this standard, which is likelihood of confusion and is the standard that's applied on a worldwide basis, as a very low standard. It really tests whether two trademarks are confusingly similar because they look the same, sound the same, or they're used in connection with similar goods or services. And essentially, this is kind of the opposite end of the spectrum from the criminal law standard you're familiar with, beyond a reasonable doubt. With likelihood of confusion, if you get a case where 1 out of 4 or 1 out of 5 people are confused, that can be likelihood of confusion, and a plaintiff can win a case. So, infringement can have bad consequences, of course, because the cost is high, and I'll get to that in a minute, but you can lose all kinds of things. You can lose a registration. You can lose your goodwill in the brand. You can lose damages, and you can be subject to damages for willful infringement and lose profits, and that's become easier to get under some recent law changes. So this slide just shows the high cost of litigation that people often hear about, but I think it's important just to dramatize it here. The 2019 report of the Economic Survey by the AIPLA organization published these numbers, and essentially it shows that if you go through full-scale litigation, you could plan to spend anywhere from $500,000 to over $3 million. So the $3 million is pretty extreme, but for many, many nonprofits, the $500,000 would seem extreme. So ultimately, we're trying to avoid infringement. And today's focus, of course, now that we've raced through those slides, is maximizing brand value. It really is more important now than ever. And I like to use this visual representation of how you get to brand value. And if you look at the red, starting at the bottom with the foundation, you've got brand distinctiveness, availability, and exclusivity. And once you kind of get that, you're focused on brand registration and control. And together, all of that creates brand strength. You add kind of the marketing side of things and the quote business performance, and you end up with a brand value. So you see that really the core of brand value can often be your ability to register the trademark and control it. These are some trends that I've seen in the last 17 weeks after COVID from nonprofits who are looking to maximize brand value in maybe slightly different way than in the past. So first, I'm seeing that clients are moving to jettison underperforming brands a little quicker than in the past. It doesn't mean that people are cleaning house mark portfolio, but if anything was borderline or is not a high value thing that comes up, for example, for renewal, the focus is shifting a little bit, it seems, to the brands that are high value. And with that in mind, the second thing we're seeing is better protecting high-performing brands. Clients seem even more focused now than before on making sure they've got their registrations, that the licensing is correct, protecting those high-value interests. The third item is that, and this was a surprise to me, that nonprofits are moving forward with rebranding, and they're creating new brands even during this period. It's been, I think, a helpful development that nonprofits seem more focused on distinctiveness and exclusivity, and we'll talk about those. And the interesting kind of wild card for me is the fifth item, avoiding trademark litigation. So you would think that because of the high cost of litigation, this is what everybody is trying to avoid. And I'm not sure that risk tolerances have changed very much in the nonprofit space based on what we see. So I think all that's interesting. So now we're going to focus on distinctiveness. And this is something that's very well known. It's called the Distinctiveness Continuum. And I think it does take on some new meaning post-COVID, because you really want to be, you've always wanted to be as high as you can on this continuum, but now I think there's a little extra acceptance by nonprofits that it's important to do it. And so you see that we're going from weak to strong, up to down to up here, and then going to the next slide. We're going to start at the very top of that ladder. So looking back, we're starting right at the top at fanciful. So these fanciful or coined words or trademarks are very uncommon in the nonprofit space, but they're important to note. These are just made-up terms. And, my favorite example is Haagen-Dazs, because it doesn't look like it's made up, but it's such an effective brand. So those are some good examples. So this is where you want to be. You want the absolute strongest trademark, you make it up. The next level down is an arbitrary trademark, and this is somewhat more common for nonprofits. It's not as common as we would like, but it's kind of becoming more common. I've got a few, excuse my voice, examples there, including Apple in the for-profit space and Shell, which are good examples of these dictionary words that are arbitrarily applied. And so that is, what an arbitrary trademark is all about. So the next level is a suggestive trademark, and these are still fully protectable, and this is kind of a level you want to be on at the least. And this would include a lot of the initialisms or acronyms. They require what's called a moment of conscious reflection to understand what the brand is trying to convey. And so Coppertone this time of year seems like a good example in the for-profit space. And we've got Leading Age, which is one of my favorite rebrands we'll talk about, which is something that requires you to think about it for a moment before you understand exactly the goods or services that are being provided. So that's a level you want to be on at a minimum. Your kind of backup option is descriptive terminology. Now, these are things that immediately tell people about a feature or function or something about the goods or services. And so, for example, if you say we are, Leukemia and Lymphoma Society, that immediately tells people what the nature of the organization is. And so things like this can ultimately be protected as trademarks. They can be registered immediately on what's called the supplemental register, but they don't have very expansive rights at the outset. So what you're doing in this kind of universe of trademarks is, depending on time, to help give you the rights you need. Generic terms, this is where you don't want to be, and these are words like association or nonprofit that are just the common commercial terms people use for everything. So you see, you don't want to be at the generic level. You want to try to avoid the descriptive level. You're probably going to be at that suggestive level in the middle, where it requires a moment of conscious reflection. So we've got a great video here for people to watch to help break things up and dramatize the importance of trademarks. Here we go.
We're a company that's so successful that everywhere you go, you see the scratchy, hairy fastener, and you say,
"Hey, that's Velcro!"
But even though we invented this stuff, our patent lapsed 40 years ago. Now no matter who else makes it,
you still wanna call it Velcro.
You think it's awesome for us, we're famous, but we're lawyers and it's causing us grief. Cause there are trademark laws being broken. It's all here in this short legal brief.
And we know that this is confusing because Velcro brand is who we are.
But if you call it all Velcro,
we're gonna lose our circle line.
This is called hook and loop. This part's a hook, this part's a loop. You call it Velcro, but we're begging you. This is f***ing hook and loop.
We know this seems ridiculous. This is a first world situation.
And we made $500 million last year.
I went to Turks on my last vacation.
And we're asking you not to say her name. We took 60 plus years to build. But if you keep calling these Velcro shoes, our trademark will get killed. Yeah!
We aren't just doing this for us. We're doing it for all the successful brands that got so popular, people started using the brand names the wrong way. So please, remember.
If you need something to clean up your socks, do it with bleach and not with If you have blood from a boo-boo you made, this is a bandage and not a If you're exercising with someone you're dating, it's in life skating and not I know that bleach stuff is more fun to say, but if you keep doing it, our trademarks go away.
This is called hook and loop. This part's a hook, this part's a loop. You call it Velcro, but we're begging you. This is f***ing hook and loop.
All right, well, hopefully everybody could see and hear that video, which is one of my favorites and shows, just how important it is to really value your brand and help increase the value by ensuring that it's either strong to begin with, like Velcro was, or it stays strong, like Velcro is today, because of videos like this that really remind people that Velcro is not a generic term, it's a brand. And so great commitment by a for-profit business team, but shows the importance there. So now to really the meat of the trademark part of this presentation concerns best-in-breed rebranding. As I mentioned, one thing that we're seeing more of than I expected during this COVID period is rebranding. And so that could include, brand overhaul or just creating new brands in some cases. And it really is important. These are some great success stories that we've been lucky enough to have been a part of. But I really like the leading age example at the beginning because it takes kind of a heavy, difficult acronym and uses a slogan, which is quite unusual but effective for branding. You see what PMI did to buck the trend of people moving to acronyms. They actually moved away from the acronym. American Bar Association made a change as well to modernize its logo, and then Jennifer is going to make comments as we go here about the ATD rebranding, which was very successful. One thing that you note on this slide is that the left-hand trademarks, the older trademarks, are a little bit more monotone. They're kind of the blue that everybody uses, and so you can see there is a movement to color, to more creativity, to warming up brands and making them more modern. So let's talk about some of the lessons from a successful rebranding focused on Jennifer's experience at ATD. And so, Jennifer, we're going to have you jump in, but first I just want to introduce the idea that you're going to need time when you have a rebranding, and so we're going to talk a little bit about that. This slide that talks about prepare for your timeline is not a timeline that ATD used in particular, but it's just to say that there are different steps that you're going to need to take when you're rebranding. You're going to have to go through a search and clearance process for the trademark, to file the trademark application, and those steps can take a little while. And then it's ultimately going to be some time before your application is hopefully approved, and then you go into a phase of maintaining the trademark over time. But Jennifer, maybe you can jump in and talk a little bit about your experience with ATD's appreciation of the timeline that was required from 2014.
Sure, and thanks so much, Andrew, for inviting me to join you today. I'd be glad to talk a little bit about it. And maybe, if you don't mind, we could skip back 2 slides so that I could just address the ASTD logo and the ATD logo there at the bottom of 28. Thanks. So a couple of notes for everyone. Our previous brand, which we had held for more than 70 years, so it had a lot of brand equity, was the American Society for Training and Development, ASTD. Now, there were some unenviable things about that acronym, as you can imagine. Certainly made search engine optimization a little bit tough at times as well. But the brand equity that we had built over time was significant, and we have and had at that time as well over 100 local chapters in the United States, as well as international partners around the world. And so a couple of the sort of purposes or the impetus behind the rebranding was that really the field of what had been known originally, or everyone had sort of called and was training and development, had really grown broadly. We anchored the expansion of the field based on what we call a competency study, and many nonprofits and associations do these. Either they call them job task analysis, or they call them something that anchors what are the skills and the knowledge that people in your profession need to know. And so over time, through these studies, it really had become clear over the decades, really, that the profession, the work that the profession did had really grown tremendously from what had historically been known as training and development to one that was much broader than that. So that was one facet of really why the profession was really much broader than training and development. And another aspect, as you can imagine, with American as part of our name, is that as we had expanded over many decades as a global organization, we were not simply an American organization, although we were based in the United States. So that was another aspect of it too, that really were some of the key areas of focus as we embarked on that journey. And to Andrew's point about timeline it's always a lot longer than you think it is. I've talked to a lot of other nonprofit executives who have sort of asked me questions about that, and it really does take a lot of time, whether it's on the trademark side or whether it's on the building the change management plan or getting your constituents involved, your board of directors, whoever is most important for your those activities. Timeline is critical, and so I wouldn't suggest rushing that, and it takes a lot longer than you typically anticipate from the get-go. So that's definitely something to be mindful of.
Jennifer, that is terrific color commentary, and we're going to have you do more of it here as we go through some of these slides. What were some of your thoughts when you looked at the world? Like you said, you were no longer just an American organization. You'll remember that we searched the trademarks in multiple countries. And I always like to think of this process as kind of identifying key trademarks, right? And that's, what the key trademark is when you're rebranding, you look at that, but you're focused on key countries and, key goods and services. And that's all easy to say, but what did that kind of mean from your point of view?
Sure. So some of the things that we were interested in and certainly concerned about was how would the brand translate in other languages and other countries. And so we sort of took the approach of, where are our members based in these other countries, and where did we have the most penetration, I would say. And some of the areas that were really important was what is the literal translation of these words, and but also some of those sort of figurative things. How did the acronym what did it mean? What might it mean in other languages? And speaking of that, not only the translation, but also say in Asian cultures, what would the characters mean to the consumer or the potential member? or the existing ATD member that would be in those other countries, say China, for example. So those were big considerations for us that, again, you might think about, but you don't necessarily think about the time that it might take to consider those things. So that was definitely something that we wanted to look at, was the translation, but then also the meaning behind those words. And that would be something I would definitely suggest if you have a global nonprofit and a global audience, that you spend time thinking through.
Those are great comments, and as everybody can hear, Jennifer was a terrific ambassador of this new brand through the process, and a great leader in her organization, and was really both jumped in with both feet in terms of the searching and filing process and all the strategy on a daily basis for some time. That was a major rebranding, so it took a lot of work, but it when I was thinking back on it, it brought to mind couple points that I'll mention, Jennifer, and I'm not sure whether you'll have comments on these, and then we'll shift back to you more. But one of them is I like to call the China problem. So whatever your organization is, if it's at all global, it's going to have potentially a China problem. And so the problem kind of goes like this. You end up with a quote, web of infringers. And this chart actually represents a web of infringers that, colluded to try to steal the rights of a major nonprofit in China. And so they had different entities, different individuals, all doing different things, but we were able to tie them together in various ways and understand that they were all related. And there was quite a lot of effort and expense by this client to try to deal with it. So when we think about clearing a trademark internationally and then applying to register the brand there, because China's a first-to-file country, this is always in the back of our mind. Another issue that we think a lot about with rebranding, just on the kind of trademark law side these days, is, how do you identify these services that I described earlier as, the certification services that aren't really a certification mark, it's really credentialing. And Jennifer, back when we filed for you in 2014, I think it was, we were probably in class 42 for these types of services. Historically, you would find nonprofits just call this a certification mark and file in what's called class B for certification marks. And we don't think that that is often the correct place for it by modern standards. But the trademark office in the U.S. at least hasn't made our life very easy by continuing to move the ball in terms of where these things are classified. So this slide is just to say, you're thinking about the countries and country-specific problems, but also how to identify goods and services. This was really interesting about the ATD rebranding. Jennifer, can you talk a little bit about how you moved to this logo, why you did it, and what talent development meant?
Sure. So as it relates to this, we, as I mentioned earlier, we were moving. Not only were we moving to a new logo, but we were also rebranding. It was sort of a three-legged stool, I guess. We were changing the name, we were changing the logo, and we were also rebranding the profession in the field. So we had a lot of things that we were encountering and a lot of change management going on. And this was probably, I would say, one of the biggest areas, which was for the many, many, many thousands of individuals who do this work every day in organizations. We were sort of describing how the field had grown and matured and really blossomed in the many decades since ATD had been around, which has been since 1943. ASTD first and now ATD. And so we were working toward branding it as talent development, and so the Association for Talent Development. And so a lot of our work was spent talking about what does talent development mean, how has the field grown and expanded, and what does that really mean to you, our member? What does that mean to the profession? How does it really elevate your work? And so a lot of the focus and the effort and energy went toward our efforts to work on that change management, to brand the profession. And it has taken, we're 6 years after it, and we're continuing to do that, but there are definitely some really bright spots, which I think is terrific.
And Jennifer, I thought your magazine was a terrific part of the rebranding, and that logo that you came up with for Talent Development, which is the name of the magazine. You know, if you
Right.
look back, and I'll click back on the slides to your main logo, you've got ATD, of course, but you took the TD part of it to make, to give your new magazine a new brand that could be protected, and I thought did it very effectively.
Thank you. Yes. So the magazine had always been had been called, for a number of years, really training and development, and then we really started to call it TD, for short, as an acronym. And then again, as you mentioned, Andrew, really was a very easy transition to rebrand it TD, but Talent Development, to very much go alongside the new brand of the association. So that's really where that came from, and it was a very likely transition.
Yeah, it was very effective from my point of view as a trademark lawyer. So another interesting part about this process was to not forget domain names. So, there are always going to be challenges with what domain names may be available, but sometimes you can acquire names that, again, are a part of branding the field, like td.org. Did you have any other comments on the domain name issue, Jennifer?
No, you're absolutely right. We're really fortunate that we've been able to help kind of brand all these things together. The magazine, which is the flagship of the organization, has been around almost as long as the association, but in concert with the domain name, which again in this era with so much of where people find us, is through search engines. That's been really a wonderful transition for us.
Yeah, and Jennifer, we're going to have to talk offline after the Booking.com case about your td.org brand, which is something that really wouldn't be capable of trademark protection before, so that may be interesting. Another part that I really liked about the rebranding, Jennifer, that you did was that you not only took the TD for your magazine from your main ATD logo, but you also used the same color form and arrangement of letters from your ATD logo to use in your credentialing logos, CPTD and APTD. Can you talk about that for a minute?
Sure, absolutely. So we rebranded in 2014, and then previously we had a main certification mark that we most recently updated to be CPTD. In the meantime, though, the associate credential, the APTD, which is for individuals who have a few years of less experience in the field, kind of came onto the scene, and so it has been a great opportunity to connect those brands to sort of the main organization, but also leverage the opportunity because these credentials are really based on, like I mentioned way back at the beginning of this conversation, the credentials are really based on the competencies, we now call them capabilities in the field. And when we say capabilities, it's based on a model of skills and knowledge that professionals in this field need to know to be successful. And so that really grounds everything that we do, from our content to our credentials to the exams for these credentials. It grounds the content for our conferences and everything. So it really ties everything together and helps us build on professional development really for the entire profession. So that's kind of where these sort of puzzle pieces all fit together.
Thank you for that, Jennifer. And we talked, you and I've talked a little bit at various times about licensing, but this slide is a good example to say that, sometimes you have different organizations within a nonprofit umbrella, and you need to make sure that there are trademark licenses in place in cases like this where you've got a main trademark owner and then a different entity using a brand. And just a very high level touch on licensing. Licensing is very important for trademarks. It's one of those things I mentioned that folks seem to be more focused on now post-COVID. What do we need to do to make sure our licensing is correct? Well, you want to have it in writing. There's got to be quality control, by the trademark owner. And if you don't do things right in the licensing area, there can be what's called naked licensing, and there have been cases in the nonprofit space on this very thing. and that's a risk for losing trademark rights. And then the last point I think we're going to talk with you on the trademark side about, Jennifer, is how to keep legacy house marks alive. And maybe we'll just do a minute or two on this and we can pivot to copyright.
Absolutely. So I don't know if everyone can read this on the screen, but as you'll see in the kind of middle left, we have our old logo, the ASTD logo, and the arrow pointing to the ATD logo. And we've actually kept that up for the last 6 years. And the line underneath it reads, ASTD changed its name to ATD to meet the growing needs of a dynamic global profession. And we created that really at the time of the rebranding and the launch to help people understand what the purpose was behind the rebrand and why. But it also was intended to be up there for lots of people kind of come in and out of our field. They come in and out of training. They might be in human resources, or they might sort of come and go. And we kept that up there because people often find us and say, oh yeah, I was a member of yours before, and now I'm back doing training again, or I'm back in a talent development role. I remember you. Oh yeah, now I see you've rebranded. But they do anchor sometimes on the previous name, or they remember us as ASTD. So we do keep the old logo up there for to protect it, but also to bridge the gap between what we had been for over 70 years to what we are today.
Yeah. And this is very important from a trademark law point of view, to being able to keep, certain strategic registrations alive for legacy brands for a period of time due to this issue of what's called residual goodwill and the fact that brands can really live on in a way for a number of years. So with great thanks to Jennifer, who you can tell is an awesome person, and we're lucky to have ATD and as a client and Jennifer as the client contact. I want to hand things over to Megan Kent on the copyright side, and I'm going to skip these action items in view of time and move it right to copyright. So Megan, why don't you take over?
Great. Thank you, Andrew, and thanks, Jennifer, and everyone who's joined us on the webinar. And before we transition, I just want to provide the CLE code for everyone. So that CLE code today is BRANDS, all caps, BRANDS. Again, the CLE code is BRANDS. So we're going to transition now to the copyright section. I just want to take a few minutes to provide some background on copyright law to ensure everyone's on the same page, and so we can frame up the concepts that we're going to be talking about. So copyright protects creative works. It protects original works of authorship. We think of music, movies, photographs, but also text and PowerPoint presentations and software. And essentially, copyright provides a monopoly to the copyright owner. And through that monopoly, a copyright owner has certain exclusive rights. They have exclusive rights to make copies, to reproduce the work, to make derivative works, such as making a movie out of a book or putting a photo into a presentation. Exclusive rights to distribute, to perform, and to display. So how is copyright established? Well, copyright is very easily established. It exists when it's created. So when the drawing is completed, when the photograph is taken, when the software is written, copyright exists. So it's when it's fixed in a tangible means of expression. There used to be a requirement for notice and for registration, but in 1989 we signed on to an international convention called the Berne Convention, and those are no longer required. So they still have benefit, though. Even though notice and registration aren't required, we still recommend them. So as you'll see, we have the C in the circle down at the bottom of our slides. And we still recommend people use it because it puts people on notice that we're claiming copyright in our work. Registration as well, there are significant benefits. First of which is that you need a registration in order to file litigation. So if you do have to enforce, you need that registration in place. In addition, if you have a registration before infringement occurs, there are significant benefits as far as recovery. So you can recover a lot of additional damages, including statutory damages. And statutory damages are laid out in the Copyright Act, and they range from $750 up to $30,000 per work that's infringed. And that can go as high as $150,000 per work infringed if it's found to be a willful infringement. In addition, you can get attorney's fees if you have to enforce, which is an anomaly in U.S. jurisprudence. So that's another benefit of registration. As you can see, copyright lasts a very long time, and I've laid out the term lengths here. Copyright ownership. So who owns it? As a matter of law, the fallback is the creator owns the copyright. The exception is in an employment relationship. So if an employee is working within the scope of their employment, the work that they create is owned by the employer. For example, a software programmer writing software, the employer owns the copyright in that code. However, if that software programmer after work goes and takes photographs or on the weekend is writing a nonfiction book, the programmer, that's not within the scope of their employment, they own the copyright in those photographs and in that book. Independent contractors, so we're thinking here now about your volunteers, perhaps your speakers at events, other contractors that you hire, like a marketing company, for example, they're going to own the copyright in the works that they create for you unless you have a specific written agreement in place. Okay? And it has to be written and it has to be signed. And it has to fall within one of these works that's listed here. So typically what we'll see in those written agreements with your independent contractors is work for hire language, but also assignment language, just to ensure that there has been a transfer of ownership in the copyright. So an assignment is transferring ownership, and we need that in writing. And that's different from licenses, where we don't transfer ownership. Instead, you're getting a certain right to use the work. And there are a variety of different types, exclusive, non-exclusive, even implied, and they can be for certain portions or only certain types of works, geographically limited, venue limited, that sort of thing. So copyright infringement and exposure. There's a lot more exposure than people realize in copyright. Infringement essentially occurs is when there's a copyright and the work is used without permission. There is no intent required. It's a strict liability tort, meaning that even without knowledge, you're liable. So, for example, your speaker provides content and you display it at your annual conference, assuming that it was original to them or that they had gotten permission to do it. But in fact, if it included any infringing content, you're liable for copyright infringement. And you infringed by displaying it. And you didn't have any knowledge. In fact, you were acting in good faith, but intent is not required. It will impact your exposure, but it will not impact the liability. Again, exposure is quite a bit higher than people realize often. We talked about if someone has a registration in place, they can get damages up to $150,000 per work. So again, there is that extensive exposure that we have to be concerned with. What about fair use? We hear this frequently. The use is for a nonprofit, or it's educational, or it's commentary, or it's just amusing. Isn't that a fair use? Well, not necessarily, and you need to be quite cautious relying on fair use. It is an extremely subjective and fact-specific defense. And I've laid out the 4 factors here that are from the Copyright Act. And we could spend probably an hour going over each one of these factors. But the bottom line is it's a defense to copyright infringement. And it's very rare that we can give you a bright line fair use defense. Typically it's going to be, it depends. And we can either tell you it's low risk, medium risk, or high risk. Where you see more bright line fair use is with a parody. And that's different from satire. Parody is where you're mocking the work itself or making commentary on the work itself, and you have to use it in order to make that commentary or make that mockery, as opposed to satire where you're using a work to mock something else or just to be funny. So with that background, I want to turn to the current environment and the current COVID environment and what we're seeing. Everything's online. Events are going virtual, and everyone is having to move quickly to pivot to this virtual environment. And we're seeing that with a lot of nonprofit organizations who are having to change their annual meetings to virtual meetings. So we're going to focus for the next several minutes on that transition from in-person events to virtual events and how content and copyright are impacted. And now you have to think about them in a somewhat different way given this new environment. So copyright exposure in the new digital format, as has always been the case, the content that you as an organization display or distribute needs to be original to the author or appropriately cleared, okay, because of the potential for large exposure. This is even more important now from just a practical perspective, because when content's online, the likelihood that someone will discover the infringement is much higher, of course, much higher when it's available online as opposed to being presented to a room of 500 people. For example, this has been going on for a long time. Many photographers have increased their enforcement recently, and they use reverse image searching to find infringements. Well, this is much easier if everything is digital and online. So with that, just want to take a moment to mention the use of images found online. Of course, just because something's online, it's not public domain. You still need permission to use it. There can be some misunderstanding. Sometimes people think that it's out there, it's available, it's public domain, and it's not. Similarly, if something is posted on social media, it's not public domain and is not free to use. The terms of service for different social media platforms typically provide for a license within that platform. For instance, you can retweet, so that's redistributing something within the platform. Some of them may give you a sub-license if you're using their API in a way that you're hot linking or framing to the content. But ideally, you're going to get permission from whoever posted, and it can be fairly simple, simply asking them. But it's ideally you get that permission. You don't just simply right-click, copy, and use it. Enforcement is common, as I mentioned, and we're seeing more and more cases in litigation involving social media use. Creative Commons licenses, many folks rely on Creative Commons, and that can be good, but be cautious with that. Most Creative Commons licenses have restrictions, like that it has to be non-commercial, or you're required to link back to the source or give credit. And if you don't comply with those restrictions, then the license is void and you don't have a license. So what do we do? Well, despite the need for speed in this environment, continue to be as thorough as you usually are with your speakers. Speaker agreements are going to be especially important in this time. And if you don't already have these provisions in your speaker agreements, make sure they're there. You want your speakers to warrant that their materials are original to them or that they've appropriately cleared them, gotten the permission or license. We want the speakers to agree that if there is a claim, they or the agency that helped find the speaker for you will defend and indemnify any claims. These are fairly straightforward and common in agreements, and you shouldn't really get pushback on these. So it's a good practice to get into. Indemnification is not automatic in copyright or for copyright claims, so you need to have it in your agreements. You also want to take a look at your speaker agreements and articulate the license that they're granting you. And make sure that you have permission to use the speaker materials that they provide in the new and different ways that you may be using them, like live streaming and recording or providing more electronic access than perhaps you would have in the past. Finally, I want to talk about music and virtual events. Music licensing is a whole separate complication in the digital environment, and it can be quite complicated. There are a lot of different rights and multiple copyright owners and several different types of licenses that you have to consider. So just a quick background so we can talk about it. Music includes two primary copyrights. First is a musical composition, which covers the music and the lyrics, and this is typically owned by publishing companies. There's also the sound recording, which is the recording of a particular performance, and that's typically owned by the record labels. Sorry for the small font here, and I won't go over all of it, but this gives you a sense of the different types of music licenses. For our purposes, we're going to focus on a couple of them. The public performance license is the one at the top. Public performance license allows you to play music at an event, like at a conference. And you get these from PROs, from performance rights organizations like BMI or ASCAP or CSAC. For example, bars and restaurants have them so that they can play music at their establishment. Conference centers and venues typically have them as well, and many of you likely relied on those when you were planning your annual events or conferences. So at a networking event in the evening, after the seminars were done, there may have been music playing, and you could rely on the venue's license with the PRO. Some organizations have PRO licenses for their own space and for events. They're sort of traveling licenses. And all of these PRO licenses are fairly straightforward, and you get them from the PROs. The second and third, I'm going to talk about just very briefly the sync license and the master use licenses. For today's discussion, these come up when you begin recording events where music is incorporated into a recording. So for those, you're now synchronizing music and video, and you need sync licenses and master use licenses. If you're using a pre-recorded music, you'll also need the master use. These, unlike the public performance licenses, these are licensed case by case with the music publisher and the label, and it can take a lot of time, it can cost a lot of money, and they may just refuse to allow the license. So bringing it back to the virtual events, your platform is your new venue. And if you're playing music as part of a virtual event, you're either going to need that platform to have a license in place with the PROs, like your venue used to, or you're going to need to obtain that license for yourself. And if you already have a traveling license, so to speak, for your organization and your events, you will likely need to renegotiate that and expand it to digital use, as many of them were simply for physical venues. So something to consider if you already have those licenses in place. As far as recording presentations, if there's music and you're going to be recording any of the virtual events you're offering, be aware that you're likely going to need a sync and a master use license, which can become very complicated. So what do you do? Again, despite the need for speed, we need to be as thorough as usual with your venue agreements and with now your digital platforms. So some things to consider when you're selecting a platform. Are you only going to live stream, or are you also going to record? Will there be any music in your live stream or your recording? Who's going to own the recording, and how else could it be distributed? Is that recording going to be controlled by the platform and only be available through the platform? Or will you be able to use it outside of the platform? Does the platform allow you to limit access to registrants in a way that makes sense for you and for those registrants? And then consider, if you are going to have any music, whether your platform has licenses in place already with any PROs. Very few do, but it's certainly worth asking. And if not, making sure that you obtain those. Finally, and I'll go through this quickly, I know we're running out of time. If you're recording and there is music, there are alternatives, and I've laid them out here, but I know we're running out of time, so I'll leave it with that and open it up for the questions that have been coming in.
First, I was going to ask Megan if Jennifer has anything that she wanted to add on the copyright side.
Great.
Oh, no, nothing from my end. Thank you. Thought that was great, Megan.
Okay. Great job, Megan.
Thanks.
So
let's see.
Megan, I see we have a copyright question, and because we took some of your time on trademarks, feel free to answer it. I'm happy to read it to you.
Yep. So I'm just looking at the question right now. For music played by a presenter during a nonprofit talk, if it is live streamed and available later on demand video like YouTube, you don't need a sync license, right? Question mark. Fair use? Question mark. Or do you recommend a public performance? So this is exactly the question that we've been seeing coming up. Typically in the physical environment, if you had someone play music at a presentation, that would have been covered as a public performance with whatever license the venue had in place with the PROs, and so you would have been fine. Now, when you're live streaming, it's still a public performance, so you're going to need that PRO license, either yourself or your platform will need that license. And then if you get into the recording, you are synchronizing, if the music is part of the recording, you're synchronizing audio and visual, and you do need a sync license for that, as well as potentially a master use agreement, master use license if it was a pre-recorded song and they weren't playing it live.
And Megan, we had one question I see on the trademark side that came in early, and it says, what is your opinion on the need to trademark nonprofit fundraising campaign names? They act as a kind of sub-brand. So, a lot of what we think through with the trademark analysis and whether it's important to search and clear and register brands is, how important they're going to be, how prominently they'll be used, and how long they'll be used. Generally speaking, I would say that, nonprofits are obviously highly focused on charitable fundraising and other types of fundraising in many cases. And, that because that can be a big source of attention and fundraising for the organization, it's important to make sure that brand is clear in most cases. If it's a very short-term use that you can change easily, there is inherently then less risk, and you may be willing to kind of tolerate more risk. So I see we are about to the end of the hour, and Jennifer and Megan, I'm not sure if you have anything else to add.
No, nothing from me.
No, nothing from my end.
Well, I just wanted to thank Jennifer in particular on behalf of Megan and myself for joining us on this. I think you provided, real terrific color commentary on the trademark side of things as it relates to rebranding, Jennifer, and again, appreciate the chance to work with you on a regular basis. So with that, I think we will say farewell and thank everybody for listening in and watching this webinar.